I'm a partner with Dinsmore and Shohl, and I'm the secretary for the Labor and Employment Committee, here with Andrew Casey, Steve Simon, also in the officers of the committee. I am so excited to introduce our speaker today, Senator Bill Seitz. Senator Seitz is a summa cum laude graduate of the University of Cincinnati with a bachelor's in history. And after graduating college, Senator Seitz went to University of Cincinnati for law school and was a member of the board of the Co-op and Law Review. Following law school, Senator Seitz went and joined Taft in the litigation department and became partner in 1986. And following Taft in 2014, Senator Seitz joined Dinsmore as a counsel, which we're of course very excited about. Prior to joining the Ohio Senate in 2007, Senator Seitz served in the Ohio House of Representatives for 7 years. There he rose through the ranks, serving as Majority Whip and Assistant Majority Whip and Chair of the Civil and Commercial Law Committee. Currently, Senator Seitz serves as the Chairman of the Public Utilities Committee, Vice Chair of the Government Oversight and Reform Committee, as well as a member of the Civil Justice, Criminal Justice, Energy and Natural Resources, Finance Corrections Subcommittee, and State and Local Government Committees. I think it's very good. In 2015, Senator Seitz was named Southwest Ohio's best antitrust lawyer and was named State Legislator of the Year by the United States Chamber of Commerce Institute for Legal Reform. We are so excited, and Senator Seitz will talk to us about the pending legislation.
Thank you very much, Faith. I appreciate the introduction. And hello to all of you, and also hello to our friends in Akron who are videotaping this today, because the Akron Society of Human Resource Managers is also interested in this topic. And I said, well, rather than me drive to Akron, we'll just videotape this, and that will serve our friends in Akron. I have recently introduced Senate Bill 268. This is legislation that is brought to us by the Ohio Chamber of Commerce and supported by all of the various business groups within Ohio. It is called the Employment Law Uniformity Bill. Not that I'm a big fan of calling bills by euphemistic names, but the bill does make a number of, in my opinion, wrong overdue changes to Ohio's anti-discrimination laws. I will start with perhaps the most difficult part of the bill first, which is we're trying to bring some clarity to the appropriate statute of limitations within which to bring all manner of discrimination claims. As you all know, presumably, Ohio has a judge-made 6-year statute of limitations on the Ohio employment discrimination law, 6 years. And that's been that way for about 22 years. When the Ohio Supreme Court first decided that a 6-year statute of limitations was appropriate, Justice Alice Ruby Resnick, a Democrat, indicated that I beseech the General Assembly to reclaim this issue and resolve it on the legislative level, as between the 6 years that was created by the court in Cosgrove versus Williamsburg Management Company in 1994, and the alternate that was then being proposed of a 1-year statute of limitations. So here we are 22 years later, and the Ohio General Assembly still has not taken Justice Resnick up on her offer that we, the legislature, should establish the statute of limitations and not enforce it. So what are we doing in this bill on the statute of limitations? Well, we are aligning Ohio law more closely with federal law by creating a 365-day statute of limitations within which to file civil actions in court or claims with the Ohio Civil Rights Commission. That is, as you know, more generous than federal law, which affords only 300 days within which to file your claim with the EEOC. So we're giving you 365 days. That is 65 days more generous than federal law in terms of when you must file with the administrative agency. What we're also doing, however, unlike federal law, is preserving the right of a plaintiff to go either directly to court or to the O.C.R.C. As you know, under federal law, in most cases, you have to go to the EEOC and exhaust your administrative remedies there before you are permitted to file a case in court. The Ohio Civil Rights Commission is simply not staffed up requisitely to handle 100% of the volume of claims that might come its way were we to require that you have to exhaust your remedies with the O.C.R.C. before going to court. So what we're doing is we're saying, okay, look, you can either go to the O.C.R.C. or you can file your claim in court. You are not required to exhaust your administrative remedies with the O.C.R.C. before going to court. If you want to go to court on day one, that's fine. If you want to pursue the O.C.R.C. first, that's fine. We are saying you can't do both simultaneously. Employers should only be forced to fight on one front at a time. But we are giving folks the election as between going to the O.C.R.C. and going to court. And we are further providing that the 1-year statute of limitations within which to file your court case will be told, suspended, during the period of time that you are up at the O.C.R.C. trying to get things resolved administratively. So that, for example, if on day one you filed with the O.C.R.C. and 300 days later the O.C.R.C. failed to resolve the matter to your satisfaction as a plaintiff, you would then have that 300 days added to the civil statute of limitations, so that you would still have at that point 365 days in which to file your case in court. So it is a tolling of the statute of limitations during the time that if you elect to go to the O.C.R.C. As you know, under federal law, you cannot go to court until you exhaust your administrative remedies with the EEOC. So what we are trying to do is provide some flexibility. Now, I've heard some complaints which strike me as rather far-fetched, frankly. Consider the case of a plaintiff who waited 364 days to file his case with the O.C.R.C. And then after the O.C.R.C. finished with that case and it was not resolved, then that employee would only have 1 day remaining because he wasted the first 364 days before doing anything. He would have only 1 day remaining within which to file his court case. And they said, well, isn't that terribly unfair? And I said, okay, look, I don't think that's very likely to happen, but in the event that does happen, I am willing to amend the bill to give people some additional time if at the conclusion of any O.C.R.C. proceeding there is less than 30 days remaining on the 1-year statute of limitation, I'll give you 30 days. Okay, that's just by way of example of some reasonable accommodation that we're entitled to, that we're going to try to make. Now, the second thing, and the thing that is absolutely non-negotiable in this bill, is we are going to make Ohio anti-discrimination law like federal law in respect of establishing the principle that individual supervisory employees and managers are not liable under Ohio anti-discrimination statutes. As you know, there's Sixth Circuit authority, Watson versus GE, Sixth Circuit case from 1997, that says that individual supervisory employees of an employer are not liable for employment discrimination. The company is liable. The business entity is liable. The employer is liable. But the supervisory or managerial employee, unless he or she happens to also own the company, but except in that case, the individual supervisory employee or the individual manager is not the employer. And as you know, in Ohio, we departed from that very important rule way back in a case called Gennaro. It was decided some long time ago. I can't remember off the top of my head how long ago, but it's been around for at least 15 or 16 years, when we had a very, very different Supreme Court. And in Gennaro, the Ohio Supreme Court said that individual supervisory employees can be held liable, just as the employer can be held liable. And this has created all manner of gamesmanship, frankly, on the part of the plaintiff's bar. Number one, it often is used to destroy diversity of citizenship, preventing the employer from removing the case to federal court. You file suit against the individual manager and the company. The plaintiff and the individual manager are from the same state. No diversity, no removal. In addition, it is set up tensions as between the individual manager or employee facing personal responsibility, personal liability, and the employer, in which the employee is probably going to want separate counsel. Indeed, that has happened. I talked to Jan Hensel, one of my partners in Columbus, at Dinsmore. She said, yes, she has had that happen, where the individual employee gets separate counsel from the company, so you've now doubled the legal expense, all right? And you set up a dynamic where the individual employee might want to settle because of the fear of personal liability, whereas the corporation does not want to settle, so you're actually inhibiting the orderly process of settlement of these cases, all to the benefit of the plaintiff's bar because they have the right to name individuals. So you might say, well, why shouldn't the individual be responsible? And my first answer is, because of what I said a minute ago, the individual is not the employer. Moreover, the Ohio Supreme Court in Hauser versus Dayton Police Department, just 2 years ago, 2014 case, ruled that public entity supervisory and managerial employees cannot be held liable under the Ohio anti-discrimination laws. So now we have this interesting conundrum whereby under federal law, the individual supervisory employee cannot be held liable. The public entity supervisory or managerial employee cannot be held liable under Ohio law. But the private entity supervisory or managerial employee can be held liable under Ohio anti-discrimination law per genero, even though that same person performing those same supervisory duties working for the Department of Transportation or the City of Cincinnati or Hamilton County or the Ohio Civil Rights Commission would not face any liability at all. I find that ridiculous, that public employee supervisors should have greater protection than private entity supervisors. And I find the whole proposition ridiculous on its face because, as I say, these individual supervisory employees are not the employer. They're not writing the check to the individual employee that was discriminated against. That's coming from the business entity that is the employer. So we are going to stop that nonsense. We're one of the very few states that allows individual employees to be held liable in this context. And we are going to put an end to the mischief that has been brought by the genero case. Now, a common refrain among my hyperventilating plaintiffs' bar friends is, well, this simply creates the Rapist Protection Act, they say, because these individual supervisory employees will no longer be liable under the Ohio anti-discrimination statutes, and they will therefore be free to molest, maim, rape, assault, batter, defame, etc., harass the employees at will without any liability at all. And maybe those folks didn't go to law school where I did, where we learned about something called torts. So if in fact there is actual molestation, rape, etc., I believe Victor Schwartz, who taught me torts and is probably the most famous torts professor alive in the world today, would tell you that yes, you have a claim for assault and battery. You might have a claim for intentional infliction of emotional distress. You might have a claim for libel and slander. You might have a claim for defamation. There are all kinds of tort law claims that can still be brought against an individual employee who misbehaves so egregiously. And indeed, those claims are unaffected by this bill. Those claims would be brought under Ohio's tort law, which was most recently revised by me in 2004 to impose, among other things, non-economic damage caps and punitive damage caps, which brings me to the next part of the Employer Uniformity Act. We are going to mirror federal law on non-economic and punitive damage caps. As hopefully you all know, those caps in federal law are $50,000 up to 100 employees, actually from 14 to 100 employees. $100,000 for 101 to 200, $200,000 for 201 to 500 employees, and $300,000 for folks that employ more than 500 employees. Those are the exact same caps that are put into this bill in Ohio, with one exception. We are actually being more generous to plaintiffs in the new bill, because we are saying that employers with as few as 4 employees, not 14, if they have only 4 employees, the $50,000 cap applies. So we have liability in Ohio anti-discrimination laws for any employer that has 4 or more employees, whereas the federal system is 14. So we are again being somewhat more generous to Ohio plaintiffs than federal law would allow. We are also attempting to codify, and my plaintiffs' bar friends have pointed out we may have done it imperfectly, but we are attempting to codify the affirmative defense that has been recognized by, among others, the United States Supreme Court, whereby an employer will have an affirmative defense if they can prove that they had an effective anti-discrimination policy, properly educated employees about that policy, and complaint procedures whereby that policy can be vindicated, exercise reasonable care to prevent or promptly correct any unlawful discriminatory practice, and that the complainant failed to take advantage of any preventative or corrective opportunities that were available to he or she. That's what we're trying to codify. I can't remember the name of the U.S. Supreme Court off the top of my head. I'm sure you guys do. I'm an antitrust lawyer, not a labor lawyer. I'm sure you guys are familiar with that affirmative defense recognized in federal law. And we're going to make that an express statutory affirmative defense in Ohio. Also, in the bill, we are trying to streamline the many different ways currently provided by Ohio law to address age discrimination claims. I'm told that they have currently 4 different avenues of redress with different remedies and limitation periods. And so we're changing the law governing age claims to be uniform with all other types of discrimination claims, subject to the same remedies, same statutes of limitation. Now, the plaintiff's bar has made a number of objections, as you might expect. Some have merit, most do not, in my opinion. But they have one point that I think does have, frankly, a great deal of merit. And that is that under Ohio law, you do not, as a successful plaintiff under the Ohio anti-discrimination statutes, you do not get attorney fees unless you also get punitive damages. So there is no statutory right to attorney fees except in those limited circumstances under the Ohio anti-discrimination statutes. Under federal law, as you know, generally the contrary is true. If you are successful, you do get some measure of attorney fees. My guess, although they've never said so, is that the plaintiff's bar is very much inclined to say, well, if you're going to make this uniform with federal law, give us attorney fees. And my further suspicion is, if they get some measure of attorney fees, a great deal of their heated opposition may melt away. But I think they raise a good point, which is that if we're going to be uniform with federal law, we should try to make it as uniform with federal law as we can. The advocates of the bill, the business groups, have said, well, we really don't want to give attorney fees because what we're trying to do is, if the damage caps are the same under state law as under federal law, and you don't get attorney fees under state law, but you do get attorney fees under federal law, we'd like to steer more of these cases into federal court, where they think the judges are better and the dockets are quicker, etc. Frankly, as a Hamilton County Republican, I don't know what they're talking about. I always tell people, for God's sake, don't go to federal court down here. Stay in state court where all your friends from the Delhi Republican Club will be the judge in your case. So I don't understand that. But then again, I don't practice in Cleveland. And perhaps if I practiced in Cleveland, I might feel differently about the utility of federal courts. And if they're trying to say that we shouldn't we should not allow attorney fees in state anti-discrimination cases because we're trying to force more cases into federal court. That's just the same kind of gamesmanship that we're trying to stop on the other side by getting rid of the Gennaro personal liability rule. I'm told that we need to tweak the affirmative defense that is in the bill to make it clear that that affirmative defense is not going to be available if the employee failed to follow internal procedures in a reasonable belief that he or she would be retaliated against. Apparently that is an additional proviso of the federal affirmative defense case law. And if that is indeed the case, and we're going to check that out to be sure that is indeed the case, I'm willing to look at that. And also, it was pointed out that when we wrote the statute of limitations, we are saying this is the statute of limitations for claims by employees against employers, but we didn't say this is the statute of limitations for claims by employers against employees. And I'm not aware of too many cases where employers are bringing anti-discrimination cases against employees, but you know, we are extending the statute of limitations here for employment-related claims, such as promissory estoppel and the like. So to that extent, I assume there could potentially, theoretically, angels dancing on the head of a pin, be some claim by employers against employees on those kinds of theories. And if that is indeed the case, I'm perfectly willing to say that this applies to actions by employees against employers, as well as to actions by employers against employees under the old theory of what's sauce for the goose is sauce for the gander. So, those are the essential elements of this bill. If there are additional elements, we can discuss them. But where we are is I've been given the opportunity to have sponsored testimony on the bill. I will tell you that in my humble judgment, the bill is not likely to move before November. You say, well, why is that? Well, it has nothing to do with me, I assure you. But the General Assembly has a curious way of taking matters that are contentious and shoving action on such matters off to the period that immediately follows the general election and precedes Christmas. It is affectionately known as the lame duck session, because that then makes you as far away from the next election as possible. And people who otherwise didn't want to deal with contentious issues prior to the election oftentimes find that, well, okay, now's as good a time to deal with it as any. And so if I'm a betting man, I would predict that this would be much like our previous tort reform efforts, the vast majority of which also passed in years gone by in that little interlude between November and Christmas time. So, you know, that's just a prediction. And it may not pass at all, you never know. But we're trying to line up an appropriate House sponsor for a companion bill. The Senate has a good deal more lawyers in it than does the House. So the House Republican lawyer contingent is pretty stretched thin, but we're going to try to get that done. And with the unified support of the employer community, groups like the Society of Human Relations Resource Managers, the Chamber, the MFIB, et cetera, the man-for-hire manufacturers, we think we've got a reasonably good shot. This is something, to me, that is something we needed to clean up in Ohio for quite some time. As I said, Alice Roby Resnick asked us to reclaim the statute of limitations 22 years ago. We haven't done it. Gennaro, which was an outlier, I remember hearing about Gennaro from Mark Stepaniak, one of my former partners at TAF. The first year or two I was in the General Assembly, I heard about what an outrageous decision that was. And patterning the non-economic damage caps after federal law strikes me as making a lot of sense, particularly because we have now placed non-economic and punitive damage caps on a whole wide variety of other, almost all other tort cases. So it seems to me that the time is right to make these changes in Ohio law. With that, I will be happy to stop now and see if you all have any questions, and invite your questions. So, thank you.
I have a question.
Yeah.
Hi. I'm Elizabeth Tuckamore, and I'm with the plaintiff's bar. I'll try not to hyperventilate. First of all, I want to say thank you for coming here and explaining this. I know that the organization that we belong to is definitely been in touch with your office, and I know that OWILA appreciates the listening ear, and it's very gratifying for me to hear that that in thinking about this bill, that you're willing to kind of take some of that into consideration. So I want to say thank you for that. First of all, and I also want to say thank you for at least an attempt to fix the age discrimination election remedies situation in this law, which is just ridiculous from, I think, both sides of the fence. You shouldn't need a lawyer in Ohio to figure out how to file your charge of discrimination and where and how to do it. The one thing that I would say is this, is that the intention is to mirror the federal law. The federal law allows 90 days for someone to decide what to do with their claims once they've been dismissed by the EEOC. As somebody who counsels clients who are supposed to be filing, really should be able to file their own charges, and then if it gets dismissed, which it usually does for resources reasons, and go consult with an attorney to say, hey, this is the deal, this is what they gave me, what do I do with this? 30 days is just not enough time. I can't even get the Freedom of Information Act filed from the O.C.R.C. or the EEOC really sometimes within 30 days. Then you give them basically almost no time to find a lawyer, consult with them, read the file, get into it. Why not just give them the 90 days? I appreciate the tool. 90 instead of 30 seems much more workable out here.
Well, that's a reasonable suggestion. I mean, that's why we're doing this roadshow, and that sounds like a reasonable suggestion to me. I mean, we are suspending the running of the statute of limitations while you're fiddling around with the O.C.R.C. Okay, so if you are diligent in prosecuting your case with the O.C.R.C. and they ultimately say no dice, or whether or not you're not happy with their resolution, all right. If you were diligent in going to them promptly after the event that precipitated the complaint, you'll still have the better part of a year left, all right? But if you were not diligent in going to them, if you let 6 months or 9 months or conceivably as much as 364 days go by before you ever registered your complaint with the O.C.R.C., then that circumstance could arise that you mentioned, where when they say no, you have a very limited period of time to get a lawyer and file suit. So, you know, we were trying to recognize the balance by including this tolling provision. To my knowledge, well, there is no tolling provision under federal law because you're required to go to the agency first. All right, so there's no reason to, and they only give you, what do they give you? 300 days to go to the agency, right? That's the current federal law. Okay, so we're giving you 365 days to go to the agency, court to court. But if you're saying that 30 days is not enough, so the way it would read was, if at the conclusion of the O.C.R.C. proceedings, the remainder of the statute of limitations available to you is less than 90 days, it shall be adjusted so that you have 90 days. Is that the kind of concept you're talking about?
Right, exactly. So the EEOC, if you go on day 299, you still get those 90 days at the tail end. Really,
well, that's right. To me, I mean, you know, without vetting it through everybody else, but that's reasonable to me. In fact, if you want to write that up and send it to me, send it to me.
All right, there my first lobbying gig.
Well, there you go.
But just with your opposition, it would avoid placeholder lawsuits being filed on day 29 and 30 as well, which might not ever get filed.
Right.
And that's something that lawyers end up doing, is this is how you do it. Here's a copy of a complaint that was filed already,
right.
Put your name in here and go down to the courthouse.
Right.
And that's a lot of expenses.
And
lawyers
you
have
know,
to deal with it.
And you know, there's got to be some give here on this whole thing, because I recognize we're going from 6 years to 1. Now, if you recognize, but you got to recognize, very few states, if any, give people 6 years, okay? 6 years. I mean, that's an awfully long time. Remember, against the backdrop of other legislation we have passed in the last 60 years. When I went to law school, the statute of limitations for breach of a written contract was 15 years. What is it today? I think we cut it to 8, and they wanted to cut it to 6. Okay, now that's breach of a written agreement, where you have the written agreement, okay? We have shortened the statute of limitations in myriad other contexts as well, all right? Tightened it up for medical malpractice and malpractice claims and so forth and so on. So the trend in Ohio has been to shorten statutes of limitations. I'm carrying another bill right now for the Ohio Bar Association, which cuts from 21 years down to 4 years, the time in which you can protest the technical defect in the recordation of an instrument, okay? That 21 years, the Bar Association said that's ridiculous, the land title people said that's ridiculous, the national average is more like 4 or 3, so we picked 4, right? The trend is to shorten statutes of limitations. And when so much of this discrimination business often revolves around what he or she said or did, as opposed to some documentary evidence that would substantiate what's going on, I think a shorter statute of limitations is appropriate. But recognizing that we're going from 6 to 1, there's certainly some give in the overall proposition. And again, we would argue that if you are diligent in going to the O.C.R.C, and it takes, I'm told, about a year to run through the O.C.R.C, is that right? Huh? It depends. But you know, if you're diligent,
which office and
well, if you go to the O.C.R.C and you're diligent about going there, as a practical matter, we are really giving you 2 years, because if it takes a year to go through O.C.R.C, you still got a year left. If you were diligent in going there in the first place, you still got about a year left in which to file your case. Yes.
So when you say the conclusion of the O.C.R.C. process, so you could go through the O.C.R.C. process, have an investigation, have a probable cause letter issued, and then have another year before you actually have a hearing. So is the statute told from the period in which you get a final order after a hearing? Even after you have a hearing, it might take 6 or 12 months in order to get a decision from the ALJ.
It's upon the complete conclusion of the O.C.R.C. proceedings.
So that would mean a final order from the commission in regards to it after a hearing.
I think that's what it means. The intent is that when you are completely done with the O.C.R.C., the statute of limitations is suspended for the entirety of the time you were there. Okay?
In my question I'm not sure I fully understand your election remedy. So I could file a charge with the O.C.R.C.
Yes.
Say it takes them 6 months to dispose of it.
Yes.
And I have 6 months and I can sue. So I can still do both.
You can do both, but you can't do both simultaneously.
Okay.
You must elect as between going to the O.C.R.C. or the courts. If you are in the courts, you can't go to the O.C.R.C. If you are in the O.C.R.C., you can't go to the courts until you're done with the O.C.R.C.
Yeah, see, I would suggest a firmer election of remedies where it's like do one or the other, but not both. And
Well, we are saying do one or the other, but not both simultaneously.
Well, yeah, but the thing is that in the O.C.R.C. you could culminate in an adjudicated proceeding where you have a hearing from the ALJ, they issue a ruling, just like a bench trial. And so if you go through that and the judge will either for you or against you, you shouldn't, under your bill, as I understand, they can then still go to court, right?
My understanding is that's right.
And then what, there would be a damages offset, I guess, or?
Well, that I don't know, but I understand where you're getting at. Kerry is an employer lawyer, okay? He represents the employers, okay? So, you know, I'm here.
Really?
Well, he doesn't. So I get it. And I think, first of all, legislation to address these issues is not new. It's been batted around a number of times. And for those of you that have followed the history, you'll see that we continue to make it narrower and narrower. I believe in earlier iterations of this bill, it might have been something more like what you said, okay? But the plaintiff's bar howled and screamed and about that, so we said, okay, we'll try to balance that. In prior versions of this bill, there was attempts to deal with the religious expression issue, for example, which is, you know, now rather controversial in North Carolina and other places. That's not in here at all. We're not going to go into the bathrooms, okay? We're not doing that, all right? So, you know, so we've pared it back. The only essential non-moving part to me is no more Gennaro and the non-economic damage caps that are prescribed by federal law, okay? Negotiate on statute of limitations, negotiate on election remedies, tighten up the affirmative defense to make it truly square up in the same four corners as the relevant federal authority grants you an affirmative defense. Make things mutual. Whatever we're saying, employees have limits against the employer. Employers should have those same limits against the employee. So that's what we're trying to accomplish, okay? And that's just what we're trying to accomplish. Yes, ma'am.
I just wanted to put in just a brief plug for the attorney fees that seems to be on the table.
Yeah.
I don't know, I think sometimes in the rush to kind of, you know, think about, you know, plaintiff's bar and that kind of thing, there's a reason why these statutes, these federal statutes include attorney's fees, and it's because the plaintiff's bar acts as essentially a civil rights enforcement arm. You mentioned that there are not resources at the O.C.R.C. to adequately combat the discrimination that I'm sure never happens in any of the cases, in any of the defense bars, you know, defense folks here. But it does happen. It does happen. And, you know, I've lived it myself. So if you don't give people attorney's fees, then you're essentially letting these smaller employers off the hook to a certain degree, because attorneys like me are not going to be willing to take on a minimum wage person who's making, you know, either be it $9 an hour or $15 an hour. If their lost wages are $30,000 in a year and I'm not getting attorney's fees, I'm not going to take that case. So if there is a lack of resources for the O.C.R.C., I think in, you know, the civil rights movement intended us to be compensated for that.
Well, and I'm generally not a fan of statutory attorney fees, but I'm also a person who likes to be somewhat consistent. And if the idea is we're trying to make this more like federal law, we can't just cherry pick what part of federal law we like. So to your point, I said I would be willing to talk about including an attorney fee provision. I'm not sure the exact same one under federal law, because I don't want the threat of attorney fees in excess of the award to impel small, stupid employers into settlements that are potentially going to put them out of business, because the attorney fees might go higher than what the actual damages are. So we'll have to work on the level of entitlement of attorney fees to facilitate settlements before trial on reasonable economic terms. So if we need to incentivize lawyers in the cases that you mentioned to take those cases with some level of attorney fees, I am telling you, as the bill sponsor, I'm willing to have that discussion, as long as we're not talking about sky's the limit, okay?
I would just ask that the Senate appreciate that I should get paid as much as defense attorneys practicing.
I do. I mean, we passed another one of my bills earlier this year, and I don't know if you do any attorney general work or not, but we passed, it was called the TPAC bill, which I can't remember, Transparency in Private Attorney Contracting Bill. But what it does is it limits the amount of money that the Attorney General can pay special counsel in the cases where the AG goes out and gets some a hotshot plaintiff's lawyer to file a big action against somebody or group of companies. And we had a sliding scale in that bill where the higher the damage award, the lower the percentage of the award could be claimed by the plaintiff's lawyer, okay? The lower the damage award, the higher the percentage could be claimed by the plaintiff's lawyer that the Attorney General contracted with. And this legislation has been in place in a number of other states. We put it into effect in Ohio. I believe it was, time flies, I believe it was about a year ago. So that kind of concept is something that we've recently done. That kind of concept is something that might be subject to discuss here too. Okay? Yes, sir.
You know, and in the federal court, in a race case, you have 4 years to file the legitimate claim. You're not limited by EEOC 90 days, because there's another federal statute, so.
That's the 1981?
Right.
Right, but
Right.
that's as I understand it, that's a very, very limited kind of case.
Well, I don't think it's so limited in a race case. What I'm asking you is.
It's a civil, isn't that the Civil War slavery?
Right, right, but it is used in any kind of race case. Is your bill going to limit that because it's based on state law? So they look at the tort law, which is 4 years, and that's where they get the 4 years. Does your bill have anything to do with that 1981 claim?
I think it does impose the 1 year on the 1981. Well, it can't impose a limit on the 1981 claim, but if there is any state law analog statute, is there a state law analog statute to 1981? I don't think there is.
There isn't. It's the 4-year tort law.
Well, then the 4-year tort law would presumably continue to apply.
So currently.
But 1981, you got 4 years,
Right.
okay?
Right.
Well, that's a federal claim.
Correct. But
All right.
it's based on state law. The statute of limitations is based on state.
Okay, well, I'm
So your
trying to
bill,
change that.
currently your bill's not going to limit that.
I don't think so.
All right.
But if there was a state law statutory analog of 1981, we would have a 1 year. The 1 year statute is for all state law statutory anti-discrimination claims.
I have another question. When you talk about limiting the claims against the supervisor,
Yes.
you know, we see a lot of companies take the position today that the supervisor, that they're not liable because the supervisor's action was outside the scope of their employment, right?
Right.
So what you're doing now is taking away, you can't sue the supervisor, you can't sue the company, because they're going to take the position that the supervisor's action was outside the scope of their employment. You can't sue the supervisor because
You can sue the
supervisor, no, you can't, because.
Sure you can. You can sue the supervisor under any of the tort theories that I mentioned.
But sexual harassment is not a tort. Sexual harassment is not considered a tort.
Well, if it rises to molestation, rape, or defamation, or slander, or libel,
Well,
or
that's not the normal claim.
intentional infliction of emotional distress, you have tort theories, okay?
No, you have to be serious. That claim is never recognized by anybody. You have to prove so much. That claim is drawn out so many.
And I would bet that the employer has a very, very difficult time in a typical sexual harassment case that does not involve rape or molestation to argue that that was outside the scope of the employment.
Well, they do it all the time.
Successfully argue that that was outside the scope of the employment.
They do it how?
I was going to mention, there's also the Karen's versus Porter Payne, which is
Pardon me?
Karen's Porter Payne case, which is a terrible case for employers, but I think it's a pretty decent case for
Well, I know.
plaintiff's bar that involves a bad set of facts that might have made bad law, but it was available. I don't know if it's been overturned, so. Right, Steve?
Right, in the back.
Well, in the sexual harassment context, if the supervisor's actions results in a tangible employment action to the employee, the company is strictly liable under Barger and Elliott. You don't have an issue there.
Well, you do if the company takes the position that this was all outside the scope of their employment because it happened, let's say it happened at work, let's say they were employees and it happened at work, I've had that defense raised, I've had the defense raised that even though they were employees, that it wasn't, you know, it just raised, the companies raised these issues.
For sure. I mean, isn't it a traditional respondeat superior analysis, whereas the employer is responsible for the conduct of his employees unless the employer shows that the employee acted outside the scope of his authority, which is a tough road to hoe. Now, if the conduct occurred at the ballpark off work, I think the employer might have something to talk about, frankly. Okay? Yeah.
I appreciate that you're open to these different ideas. I would tell you to tell the, what you call the Chamber of Commerce that why not, we're pretty collegial here in Cincinnati bar.
We're putting what?
We're pretty collegial in Cincinnati. These bills are introduced, they don't go to the plaintiff's bar and say, hey, what would you like? if you're reforming 4112, we might have said, well, gee whiz, you really ought to add sexual orientation to the protected classes. Most people think that protected class, that sexual orientation is already part of protected class. But instead you've got this bill, and I know that when I think the last time this came through, we referred to it as the sexual predator protection.
Yeah, I think that's what they mean.
Right.
That's what I mean about hyperventilating.
But we're arguing about respondent superior, but it is true, if you look at sexual harassment cases, you're making them, from the plaintiff side, less valuable and therefore less expensive for employers in two ways. One is, most sexual harassment cases are not good wage losses cases, they're non-economic, so you're adding caps. And the second thing you're doing is demonstrating that supervisors aren't going to be liable. And management lawyers that I know in the room, I believe when they do sexual harassment training, I think to scare the managers, one of the things they tell them is that the company could get hit with a big verdict. Well, that's now off the table. And the other thing they tell them is, hey, you, Joe, could get sued individually. So, and there are cases, it's right, they're not slander cases. You rarely get an intentional infliction of emotional distress case against an individual. So if you're taking that away, you are making it more likely that there will be sexual harassment, and it's not going to be punished.
I don't think so. I've done both sides. More the employer than the employee. And yeah, the employers are concerned that if the employee comes to somebody and says, this is what's happening, that there is some action taken to stop it. If that action does not happen, then the employer becomes liable. So that it's not less likely that a claim will be brought because the employer is more likely to do something about it. And that's the reason for having in the policy, or having in the law, that if you have a policy, you educate the policy, you enforce the policy, then the employer has a defense. If the employer omits any part of that, the employer is liable. So I don't think that it's more likely to occur.
Let me say this. For your theory to be correct, there would be empirical evidence that sexual harassment is higher in those states in which there is no individual supervisory liability, and in those states that have followed the existing federal caps on non-economic damages. And I don't believe there is any evidence that you could produce that would substantiate that to be the case. All right? Again, correct me if I'm wrong, defense lawyers. If I'm wrong, correct. But Ohio is one of the few, if not the only state, that follows the Gennaro rule. Is that right? For those of you that practice elsewhere, is that right? Okay. So, if supervisory liability is essential in order to reduce the number of sexual harassment cases, then one would expect in all these other states, it would be girls gone wild, or boys gone wild, whatever, because there is no individual supervisory liability, and I don't think that's the case. And I also think the non-economic damage caps established by federal law, which establish a national standard, I'm not aware that those caps have resulted in any increase in sexual harassment since they were established. Okay? So, I hear what you're saying, that you're predicting this will result in this adverse consequence that you apprehend. But again, I would say, well, predictions are nice. The weatherman can get away with it and be wrong 50% of the time. I would be wanting to see empirical evidence that supervisory liability is essential in order to reduce the instance of sexual harassment, and I don't think you could make that case. Eric?
What about preemption of common law tort claims in the discrimination area? In the bad old days, the Ohio Supreme Court kind of recognized the wrongful discharge public policy. Then the Ohio Supreme Court reversed itself and said if there's a statute that has remedy, we're not going to do that. But you can't really count on them for sure. I mean, is the bill going to...
There is something in there about that, and I'm trying to remember exactly what that is, okay?
You should say sole and exclusive remedy or something.
Well, it doesn't say that, but it says... What does it say? And...
Because then you could circumvent individual liability by suing them in common law.
Well,
There's all kinds of issues.
I can tell you...
And the statute of limitations is longer.
Hold on a second. in the weeds here, okay? Here, the General Assembly declares its intent in amending Division B of Section 4112.08 of the Revised Code to conform to and not to overturn the holding of the Ohio Supreme Court in Collins v. Rizkana, 73 Ohio State 3rd, 65, 1995. So let's see what we say in 4112.08, okay?
That would be authorizing sex harassment.
Okay? 4112.08. No person has a cause of action or claim based on unlawful discriminatory practices relating to employment against a supervisor, manager, or other employee of an employer, unless that supervisor, manager, or other employee is the employer. Nothing in this division abrogates statutory claims outside this chapter or any claims of liability that exist against an individual in common law. The procedures and remedies for unlawful discriminatory practices related to employment in this chapter are the sole and exclusive procedures and remedies available to a person who alleges such discrimination. Causes of action based on public policies embodied in this chapter for unlawful discriminatory practices relating to employment or its state, federal, or local fair employment laws are barred.
Yeah, that language should be adequate to address most of my concern. It seems like you're carving out sex harassment claims. Like this Collins v. Rizkana was a sex harassment case involving an employer with less than 4 employees. And the court let that go. And so it seems like you guys are letting that
The
go.
language that I read you is what the bill says, but the first language I read you about Collins versus Rizkana is an express recognition that we are trying to conform to and not overturn that decision. So I think what that means is, now that I get it a little better, is we are trying to say it's your exclusive remedy. However, as to people under 4, if Collins versus Rizkana was going to let you have a claim, you still got one.
That's what
Okay?
I would do.
Okay. Yes, sir.
You said I don't have any studies, and you're correct, I don't have any studies, but to be fair, I don't think the folks that introduced the bill have presented any studies showing how the fact that there aren't damages caps or because of individual liability has forced any employers to go out of business or anything. So everyone's has their own interpretation of how the world works and how it's going to affect. I will say that I don't think employers use that threat as a big verdict and individual liability insurance supervisors. But you did quite answer my one question, which I'm sure was an oversight, because you've been very candid today, is why not make it a bill that actually, in some degree, expands 4112 and adds sexual orientation as a protected class? Because most people in the public, as was shown in that controversy with Indiana, where they have the religious rights law, most people understand that you can't discriminate in employment or public accommodation based on sexual orientation. So what's to lose by simply adding it to 4112?
Because federal law does not include that provision, and because we view that as a different subject. The fact of the matter is, Ohio has never included sexual orientation as part of its anti-discrimination statutes, and I'm not proposing to use this bill to do that. Just like I'm not proposing to use this bill to deal with bathrooms, okay? To me, that's a whole different subject. I will pretty well guarantee you that there would not be sufficient votes in the General Assembly today to add sexual orientation as part of the protected class of discrimination. It's not the law in Ohio now, it's not federal law now, and I don't believe there's sufficient votes to add that, okay? And candidly, I mean, I know this is a bit of an overgeneralization, but with race and age and gender, you have a pretty good idea if they are in the protected class, okay? With sexual orientation, I'm not ever sure how you would ever handle that. You certainly can't ask them on the, tell me if you can, but I don't think you can. You can't ask them when they're applying for employment, are you gay? Right? You couldn't ask that question. So now you're going to take an adverse employment action against somebody, and they're going to turn around and say, well, they did that because I was gay. The employer's going to say, I didn't even know you were gay, all right? I've always been troubled with how we ever go about enforcing a ban on discrimination based on sexual orientation, because I don't know how you know, right? I mean, even with religion, sometimes you know because of the particular religious garb they're wearing or whatever. You have some idea, right? But with sexual orientation, I don't know how you know.
How do you know the person's age? You don't know that either.
Well, you don't know that definitively, but I can tell that you and me and Brother Highland there are at the upper end of the scale, and we're all over 40, I can tell you that.
Courts don't buy that all the time. Though.
Huh?
Courts don't buy that all the time.
Well-
Oh, I think he was, we know he was over. We don't believe that, companies say.
Yeah, well, I'm just being candid. I don't think the legislature has the appetite to do that. We expected that question to arise. There's no question about it. But if, the attitude is, if you want to bring in a separate bill that does that, bring it in, we'll talk about it. That's been done. There's been legislation that's been introduced to add sexual orientation for about 15 of the last 15 years, but none of it has ever done.
It's the same statute. It's not, it's a point of the statute. So I understand you saying under votes, but that's the legislature's decision that they don't want to reach some compromise. But it is the same statute that you're making some instructions.
I understand. I anticipate somebody will try to bring in an amendment to do that. We'll see if it passes. Yes?
Just a comment about it and how it played out practically. I think I was telling you about this case. We handled a jury trial in defending an age discrimination case, just Ohio claim 4112. The plaintiff named the individual manager who just made the decision to terminate in his capacity. For jury instructions, they were not any different than the company's jury instructions. We tried to argue that Gennaro made some kind of heightened standard. We were trying to get it because this guy didn't even say anything about her age. He just made the decision to terminate. That's clear in the record. I'm not just, placing my side. But no, judge wouldn't do it. We ultimately got a jury verdict or a defense verdict for everyone. But this guy who's, got kids and is working his job just was going to be up basically on his own with the same standards as the company. I just felt like that was not fair and not with the purpose of the statute of faith, etc. Just practical comment.
Well, I believe we've reached our hour limit. And I don't know if the videotape goes longer than an hour, but I thank you for your good questions.